Observations on the defense of purchase for valuable consideration without notice. Chapter 3. We now come to Lord Westbury's third class of cases, which he describes as those in which there are circumstances that give rise to an equity as distinguished from an equitable estate, as, for example, an equity to set aside a deed for fraud or mistake. In these cases, the rule of the Court of Equity is, it is conceived, this: that it will not exercise its special jurisdiction to remedy fraud or mistake to the prejudice of a purchaser for value. In this third class of cases, the defense applies equally whether the purchaser has only an equitable or a legal estate. It is not meant by this that his position is as strong in the former case as in the latter, because the absence of a legal estate may cripple his power of defending himself at law. What is meant is that the possession by him of a legal interest is not needed, as in the second class, to make the defense available. We may take as an instance of the third class Bowen v. Evans, A, decided by Lord St. Leonards, when Lord Chancellor of Ireland. The facts there were very complicated, but the case may be represented generally as being one of a bill filed by a remainderman in tail to set aside a sale of the settled estate by the tenant for life as having been effected by fraud. Amongst the defendants to the suit were certain persons claiming as purchasers for value, without notice, equitable interests only. In reference to these defendants, Lord St. Leonards thus expressed himself: "It appears that Mr. G. E. Bruce, the original purchaser, granted, by way of settlement for valuable consideration, a rent charge secured by a term to be issuing out of this property before he obtained a conveyance of the legal estate, and it was insisted that the purchaser, having no notice of the fraud, had an estate which ought not to be impeached in this court. It was not denied that he, being a purchaser for value without notice, though of an equitable interest only, the bill must be dismissed as against him, with costs. And though there is a difference of opinion on the point whether a purchaser of an equity without notice can protect himself in this court as a defendant against the legal title, yet in my opinion, whether the purchaser has the legal estate or only an equitable interest, he may, by way of defense, avail himself of the character of a purchaser without notice, and is entitled to have the bill dismissed against him, though the next hour he may be turned out of possession by the legal title." This refers to the question discussed. Oh. Amongst older cases establishing the same doctrine, though without any special reference therein to the question whether the purchaser's estate was legal or equitable, we may cite Malden v. Menil, A, in which it was held by Lord Hardwicke that where a bona fide purchaser for value without notice is concerned, equity will not interfere to grant relief in favor of a party, though he has acted in ignorance of his title upon a mistake of law. So again in Bell v. Cundall, B, which was a bill to rectify a mistake in the body of a common recovery of a copyhold estate, the name of the vouchee having been inserted instead of the name of the tenant, and so vice versa, and in which the fact of mistake was apparent from a memorandum in the margin of the record, in the handwriting of the steward of the manor, in which the names of the parties were correctly given. There, upon its appearing that the remainderman had, upon the foot of the mistake in the recovery, got possession of the estate and sold it for valuable consideration, Lord Hardwicke declined to give any relief. To this same class of cases must also, as it is considered to be referred, that of Penny v. Watts, C, as decided in the Court of First Instance. The object of the bill in that case was to establish and obtain performance of an agreement by which, in consideration of a niece giving up a legacy of £2,000, to which she was entitled under her uncle's will, the uncle's widow engaged to convey certain lands to her. To this bill, the defense of purchase for valuable consideration without notice was set up by the widow's second husband, claiming under an antenuptial settlement made on the occasion of the second marriage, the legal estate in the land or some portion of the land to which the litigation related was outstanding in a mortgage, and it was contended that in consequence the defense was not available, but Vice Chancellor Knight Bruce held that the defense was available, notwithstanding the legal estate might not have been acquired under the settlement. The case was appealed, and on appeal, Lord Cottenham thought there was sufficient evidence of constructive notice of the agreement to warrant the direction by him that certain issues should be tried. Ultimately, the case was compromised, but the decision of Vice Chancellor Knight Bruce on the point of law remains. The reported cases falling within the third class are not numerous, and the distinction between the cases where the plaintiff comes to enforce an equity and those where he comes founding himself on an equitable estate may occasionally be somewhat thin. Take as an example a suit for specific performance. A, let us suppose, sells land to B and then sells the same land to C without notice, and then B takes proceedings against A and C to enforce his contract, whereupon C pleads that he is purchaser for value without notice. Now, according to one familiar mode of stating the relation between A and B, A became after the sale to B a trustee for B, and it may be said that B comes to the court founding himself upon his equitable estate. The other view would be that he comes relying on an equity rather than an equitable estate. The distinction is immaterial, assuming C to have taken his conveyance and obtained thereby the legal estate without notice, because then, even adopting the first view, the case is simply that of a purchaser who simultaneously, with the payment of his purchase money, has obtained from a trustee a conveyance made by the latter in breach of trust on his part, but with perfect innocence on the part of the purchaser. A, suppose, however, that C has paid his purchase money and obtained a conveyance which does not carry with it the legal estate. Will the defense protect C, who has an equitable title only? It is conceived that it ought, more especially as the jurisdiction and specific performance is one which the Court of Chancery is often declined to exercise in cases where a decree would entail hardship. Chapter 4. Having now examined the three classes of cases mentioned by Lord Westbury to which the defense applies, we will endeavor to extract from them some rule or principle. The first observation that occurs is that Class 1 and 3, though differing in certain respects, are more akin to one another than is either to Class 2. In Class 1, the Court of Equity was asked to give to the owner of a legal interest some equitable remedy or assistance not obtainable at law, and the answer was, against a purchaser for value without notice, we will give no assistance. In Class 3, the court was asked to exercise some exceptional head of equity jurisdiction founded on fraud, accident, or mistake, and the court declined to exercise it. In both classes of cases, the mode in which the court gave effect to the defense was by simply declining to exercise any jurisdiction whatever, in other words, by dismissing the bill. In Class 2, on the other hand, the court did not decline to exercise jurisdiction, but while exercising it, contrived to give the purchaser for value the benefit of any legal advantage he had acquired. We have already indicated A, what we conceive to be the true ground for the different course of action adopted by the court in these different cases. Where, for instance, property is mortgaged to, say, A, B, C, and D in succession, and one or more of the latter mortgagees fills the character of a purchaser for value without notice, the court cannot say, we will do nothing. Settle your disputes at law, for this would be equivalent to holding that the various rights and equities in respect to foreclosure and redemption should be disregarded altogether. The free legal mortgagee would recover possession and hold the property absolutely. In other words, the case is one in which the court must, in order to avoid chaos, exercise its jurisdiction, and the only question is on what terms as respects the purchaser for value it shall be exercised. The different mode of action adopted by the court in reference to these classes of cases suggests that the true primary division of our subject lies between the cases in which the court declines altogether to exercise jurisdiction and those in which it does not so decline. If we can define the latter, the next step will be to distinguish between the cases in which the court, though exercising jurisdiction, accords some advantage to the purchaser for value without notice, and those in which it does nothing for him. Now, it is submitted that the question whether the court is to exercise or to decline jurisdiction depends not upon whether the plaintiff comes claiming under a legal or an equitable title, nor indeed upon the nature of the title set up by the purchaser for value, but on the nature of the suit. If the suit is, as in those falling under classes 1 and 3, of such a description that the matter can be conveniently disposed of by simply declining all action, whatever that course will be adopted. But if, on the other hand, the suit be one for the determination and adjustment of equitable rights and estates in reference to property, and the effect of the court doing nothing would be to leave these rights and estates undetermined and unadjusted, the court will not decline jurisdiction. Thus, in the cases adverted to in the outset A, in which there is a fund to be administered, and the cases falling under Class 2 already discussed, and in many others, the court cannot properly decline the jurisdiction. We have next to distinguish the cases in which the assumption of jurisdiction by the court results in rendering the defense of purchase for value without notice wholly unavailing, and those in which, although jurisdiction is assumed, it is exercised in such a way as to give the purchaser the benefit of the defense. Under the former head will fall all those cases in which the court is distributing or administering a fund, and those also in which the whole legal estate being outstanding and the estates and interests to be determined and adjusted being all purely equitable, the maxim qui prior est tempore potior est jure governs the right. Under the latter will fall those cases already considered under Class 2, in which the purchaser for value has obtained the protection of a legal estate. And the same principle must, it is conceived, be applied to other suits enforcing equitable rights. To illustrate our view of the action of the court and of the applicability of the defense in a case not falling within either the first or the third class, let us suppose that the head of jurisdiction which the court of equity was requested to exercise was that of partition. In such a case, the court could not properly decline jurisdiction without leaving the rights of the various tenants in common undetermined and unadjusted, and saying in effect that they should remain tenants in common, although the law had made provisions for the release from the undesirable condition. The court must therefore, it is conceived, have assumed jurisdiction, notwithstanding that the defense of purchase for value without notice might be set up by a defendant. Next, let us consider the effect and result of the court assuming jurisdiction. We will suppose for this purpose that the bill was by a person claiming 3/4 of the property, and first let it be assumed that the whole legal estate was outstanding in some trustee or paramount mortgagee. In such a case, it would have been of no avail for one of the defendants to say, I am purchaser for value without notice of the whole property, and therefore you are entitled to no decree. Nor would it have been of any use to say, I purchased one moiety for value without notice, and you, the plaintiff, can have a decree of partition only on the footing of your being entitled to 1/2 instead of 3/4. The answer would be, the interests are all equitable, and you, the purchaser for value, have, after all, no higher right than the plaintiff. If, however, the purchaser for value should have had vested in himself, or in some person expressly a trustee for himself, a legal title co-extensive with the equitable share or interest purchased by him, and larger than was compatible with the right or title asserted by the plaintiff, then to that extent his right must have prevailed, for the court would not deprive him of any legal estate. Of course, if the purchaser for value without notice had purchased and obtained the legal estate in the entirety, the result would be simple. dismissal of the bill for petition, though not on the ground of the court refusing to assume jurisdiction against the purchaser, but because after assuming it, that form of decree would also alone meet the exigency of the case. If the purchaser for value without notice had purchased and obtained the legal estate in a moiety, then the plaintiff could have a decree for petition only on the footing of his being entitled to one half the property instead of three-fourths as claimed by him. To sum up, the defense was an absolute bar where a court of equity was asked to afford assistance to the legal title by the exercise of some special kind of jurisdiction, such as discovery, removal of terms, etc., and where it was asked to exercise some special head of jurisdiction, such as those founded on fraud, accident, or mistake, but it was no such bar where the court was merely asked to adjust the equitable rights of the plaintiff and others in the exercise of some head of ordinary jurisdiction, the exercise of which it could not have declined without leaving those rights unsettled and in confusion. But in the latter case, while assuming and exercising jurisdiction, it gave to any purchaser for value who might have acquired a legal estate the full benefit of that legal estate as an adjunct to his equitable right. The foregoing is the nearest approach we have been able to make to the enunciation of any general rule or principle governing the defense. It may be convenient before considering the applicability of the defense to litigation arising since the passing of the Judicature Acts 1873 and 1875 to say a few words as to the meaning of the expressions valuable consideration and without notice. But we shall be brief under these heads because the primary object of the sketch is rather to show the circumstances under which the defense applies, assuming the defendant who is setting it up to be a purchaser for valuable consideration without notice, and to explain what constitutes such a purchaser. As respects the meaning of the expression, whoa, valuable consideration. Well, I guess we're going to have to do without that. Oh. Must be valuable in the technical sense of the word, and that a merely good consideration as natural love and affection would not sustain the defense. Next, as to the words without notice, the question, what is notice, is a very large one. It embraces questions arising upon the County Registry Act, upon the statute law applicable to British ships, upon the complicated legislation affecting judgments and pending suits, and upon a variety of other matters not cognate to the immediate object of the sketch. It branches out into the question of actual notice to the purchaser himself, which may be regarded as the exception, and notice to his solicitor or agent, which is far more common, which last, if acquired by the solicitor or agent in the same transaction, is equivalent to notice to the principal. It passes thence to the difficult question how far and to what extent knowledge of the solicitor acquired before his retainer by the client is to be imputed to the client so as to affect him with constructive notice. It involves a question how far knowledge or notice of facts which suggest the propriety of inquiry is, by putting the purchaser upon inquiry to be deemed notice of what the purchaser who fails to inquire would have learned if he had inquired. It involves the question of the absolute duty of the purchaser to make inquiry for the title deeds and the consideration of what answer accounting for their non-production may be accepted as reasonably satisfactory. To do justice to these various topics would require time and space, at least equal to that already allotted to the immediate object of our sketch, and it is not proposed to discuss them here. Chapter 5. It remains that we should say a few words in reference to the applicability of the defense to litigation arising in the Supreme Court, and for that purpose we will state somewhat more fully the enactments of the Judicature Act 1873, to which we adverted at the commencement of our sketch. The 24th section of the Judicature Act 1873 enacts by subsection 2, that if any defendant alleges any ground of equitable defense To any claim of the plaintiff, the courts and every judge thereof shall give to every equitable defense so alleged the same effect by way of defense against the claim of the plaintiff as the Court of Chancery ought to have given if the same or the like matters had been relied on by way of defense, and any suit or proceeding instituted in that court for the same or the like purpose before the passing of the act. The 25th section of the Act enacts by subsection 11 as follows: generally in all matters not herein before particularly mentioned, in which there is any conflict or variance between the rules of equity and the rules of the common law, with reference to the same matter, the rules of equity shall prevail. Now, in reference to the enactment of the section 24, subsection 2, it should be premised that according to the more natural construction of the words used, though they may be capable of a larger one, the rule embodied in that subsection confers a right of equitable defense only in cases in which the action brought in the Supreme Court is for some purpose the same as or like to one for which before the acts of suit might have been instituted in the Court of Chancery, and it is conceived that it would not be legitimate in construing the rule first to assume the possibility of a suit in Chancery for the particular purpose, and then to consider what equitable defense might have been set up in that suit. For instance, a damage caused in respect of collision at sea, seeking to enforce a maritime lien on the ship causing collision, could not before the act have been instituted in the Court of Chancery, but only in the Admiralty Court, or in a county court having admiralty jurisdiction. Hence, to such a suit in the Supreme Court, the defense of purchase for value without notice could not, according to our construction of the subsection, be validly set up. If this were otherwise, a most important alteration would have been introduced into maritime law, it being clearly established by that law, however widely such a result may differ from equity principles. That a purchaser of a ship for valuable consideration and without notice of the maritime lien takes it subject to that lien, and it seems a more reasonable exposition of the rule to regard it as intended to preserve as nearly as may be the benefit of the defense and not introducing indirectly large and important alterations in the law. Starting then from the general principle that the defense applies only where a suit for the same or the like purpose might have been brought in the Court of Chancery, let us consider some of the various kinds of actions that may occur. As respects actions brought in the High Court of Justice with a view to obtain relief of the description embraced by either the second or the third classes of cases which we have discussed, there would seem to be no difficulty in applying the enactment of the Judicature Act. Such actions will, in point of fact, be almost invariably brought in the Chancery Division of the High Court. But even if such an action be brought in a common law division, and retained there by reason of the power of transfer not being exercised, still the construction of section 24, subsection 2 of the Judicature Act seems free from doubt. The question is, could such an action as that which has in fact have been, before the passing of the act, brought in the Court of Chancery for the same or the like purpose? And upon this question being answered in the affirmative, the same effect must be given to the defense as the Court of Chancery would have given to it. On the other hand, to the large number of actions relating to matters in respect to which no suit could have been brought in Chancery before the act, the defense will, it is conceived, not apply. Thus, for instance, chattels belonging to A are stolen and are purchased by B for valuable consideration without notice, but not in market overt, and A brings an action against B to recover his property. In such a case, the defense has, it is conceived, no application, or at all events, no application as a defense to the whole action, unless perhaps The chattels were of such a description that no damages could compensate A for their loss, in which last case a bill in chancery to have them delivered up might have been sustained. A, a doubt suggests itself, however, whether the defense, though not a defense to the whole action, may not be held valid to the extent of conferring upon a defendant, who in such an action is called upon to answer interrogatories, a right to say, I am a purchaser for value without notice, and I decline to answer. It is clear that if we go back to the time when litigants in the common law courts were dependent on the Court of Chancery for discovery, the defense would have been an answer to a bill for discovery in aid of an ordinary common law action. Thus, in Hor v. Parker B., which was a bill for discovery against a pawnbroker in aid of proceedings at law to recover plate which had been pledged by a person who had only a life interest therein and had since died. The defendant pleaded purchase for valuable consideration without notice. The plea was overruled as being insufficient in form. What Lord Thurlow considered the defense, if sufficiently pleaded, a good defense, saying a purchaser without notice and for a valuable consideration is not bound in conscience to assist the right owner in the legal recovery of the subject purchased under such circumstances. It is also clear that in the exercise of the special powers of compelling discovery conferred upon the common law courts by the Common Law Procedure Act of 1854, the right to discovery, even when the whole of the proceedings were at common law, might be excluded by the defense of purchase for value without notice. This is illustrated by the case of Gaume v. Parrott, A, which we have already discussed, B, in connection with Williams v. Lamb. The Common Law Procedure Act of 1854, however, in terms made the right to discovery at common law coextensive only with that in equity, and the question is whether under the Judicature Act 1873, which contains no such express limitation of right, the result is or not the same. If the preservation of the status quo ante is to be regarded as the key to the construction of Section 24, subsection 2, the answer to this question must, it is conceded, be in the affirmative. Status quo ante. The words of that subsection may, without unduly straining them, be made applicable by regarding the action brought as consisting of two distinct claims, that is to say, a claim to the chattels and a claim to have discovery respecting them. For the first of these purposes, a suit could not have been brought in the Court of Chancery before the passing of the Act, but for the latter it might, and to the extent of the latter purpose, the defense therefore may be held to apply. From the class of actions last considered, representing what before the Judicature Acts would have been ordinary common law actions, we must, it is conceived, carefully distinguish actions which, although wearing the general aspect of common law actions, are in effect brought to obtain by means of the improved procedure of the Supreme Court what before the Judicature Acts could have been obtained only by means of the Court of Chancery. To such actions the defense, it is conceived, clearly applies. Thus suppose the facts which gave rise to Walwyn v. Lee to be repeated. Suppose an action to be brought in one of the common law divisions of the High Court of Justice to recover from the innocent mortgagee of a fraudulent tenant for life the title deeds which the latter, representing himself to be owner in fee, had handed over simultaneously with the mortgage. Here it is conceived the subsection applies strictly and literally. The suit might have been brought in the Court of Chancery for the purpose for which the action is brought, and the defense of purchase for value without notice is a defense not merely against giving discovery, but a defense to the whole action, except so far, indeed, as such action may embrace a claim for damages in default of recovery of the deeds themselves, to which last mentioned claim the defense would be no answer. The foregoing are the best conclusions which the writer has been able to arrive at in reference to the mode of determining whether the defense applies in any particular instance, and to the applicability of the defense in the particular instances discussed. It must be admitted that these conclusions are not altogether satisfactory in result, and that the ascertainment of the applicability of the defense means of inquiries into the nature and extent of the old Chancery jurisdiction must occasionally lead to investigations involving technicality rather than substance. Thus, although actions by widows for dower or by tithe owners for an account of tithes are hardly likely to occur now, so as to afford an opportunity of citing Williams v. Lamb or Collins v. Archer as cases directly in point, still the proposition treated by Lord Westbury as established by those cases, viz., that the defense of purchase for valuable consideration did not apply where the Court of Chancery exercised a legal jurisdiction concurrently with courts of law, may at any future time give rise to the following fourfold technical investigation. That is to say, could such an action as this have been brought in the Court of Chancery before the Judicature Acts? B. If so, would the jurisdiction of the Court of Chancery have been concurrent only with that of the courts of law? C. If so, is Lord Westbury's view as to the effect of the decisions of Williams v. Lamb and Collins v. Archer the correct view? Or are those decisions to be treated as simply wrong? D. If the former is the defense wholly or only partially applicable? A. But whatever may be the doubts or difficulties attending the solution of any particular instances that may occur, this seems clear, viz., that for the present at least, a thorough knowledge and understanding of the doctrine of purchase for value without notice, as it existed before the Judicature Acts, is a necessary preliminary to estimating its applicability to litigation arising under the Acts, and it is on this account that we have in the earlier portion of the sketch dwelt somewhat more fully than might at first appear necessary on the reported decisions by which the nature and extent of the defense was gradually ascertained and determined. Well, we did it. Congratulations. You can read old stuff. All right, how do we turn this off? Ciao, Bella.